Hello, everybody. I think I'm on here. Thanks for coming out today and staying through lunch. Normally, when I give privacy presentations, it's right after lunch, and everyone's, just ready to take a quick nap. Privacy puts some people to sleep, and it keeps some people up at night. So we'll see which ones you are today. A little about myself. I work at Gardner Law, obviously, and I lead the privacy practice here. One of the things that I did in the past is work with a HIPAA-covered entity and at the state, and then also worked at Medtronic in the global privacy program. So my experience is broad in terms of global and state and federal privacy laws, especially around healthcare and a medical device. We can jump to the next slide there. So some of the common threads that I have the clicker, and I don't have to ask anyone to move this. Some of the common threads that we'll talk about in privacy to kind of kick this off, just to give some context. I think when we think about privacy law, often we think of HIPAA, we think of some of the recent changes, GDPR, some of these bigger privacy laws, and it can be overwhelming, especially when you see there are 5 state privacy laws now that have passed and been implemented or are being implemented in the US today. But what I would like to do is talk a little bit about how these laws don't have to be reinventing the wheel every time we see them. There is a level of consistency and some common things that we see, and privacy programs can help to affect compliance, reduce risk without necessarily starting from scratch every time you see the law. And I'm sure back in 2003 when HIPAA was being implemented, it probably felt like starting from scratch. And I think today we have enough kind of momentum in privacy to see some common things we can do. We'll talk about updates primarily today, so I'm not going to dig into the details of laws that have been around for a couple of years, but we'll talk about some of the changes to those laws or some things that have happened more recently. We'll talk about some things in the US and then also out of the US. And we'll talk a little bit about cybersecurity in this presentation, but this is not the same topic that Bren will cover shortly after me. This is going to be focused on data security and how that's been changing in a few different areas as well. And then some enforcement activity update too. So some common threads that we see in privacy laws, and these are not always implemented in the same way in various laws, but they do typically look something like this. There's some requirements around these areas in almost every privacy law. Transparency is a big one. When you think about a privacy policy on your website, that's probably the classic example of when you collect data about someone, when they visit your website, informing them of what you're doing with that information. That's part of transparency. HIPAA has the Notice of Privacy Practices. These other sorts of laws all have similar requirements in that area. When you think of lawful basis or the legal basis for using data, many privacy laws, HIPAA included, have a set of enumerated types of uses and disclosures of information that you're allowed to do. And outside of that, you have violations. And that's what lawful basis refers to, so identifying that before you do something with the information you have. Limiting data collection. It's a good idea generally from a privacy standpoint to reduce what you collect to what you need, but there are some laws, GDPR, CCPA in California and others, that require that you limit data collection. Additionally, storing, sharing, transferring data, almost always there's some restrictions around that. A key one is if you promise to do something with data, aka not share it, and then do share it, that's always going to be a problem, even in fairly loosely regulated spaces. Many laws require that you have contracts in place for sharing and so on, so we'll talk about that too. And then, of course, retention of information. Usually we think about retention of information outside of the privacy realm as, well, we need to keep this data for a certain amount of time to meet our regulatory requirements, or we need to keep it for business purposes. HIPAA requires 6 years of retention for compliance records related to HIPAA. But what we talk about in privacy from a limited retention standpoint is don't keep information longer than you need it for a legitimate purpose, for regulatory reasons. Once you reach that trigger, many laws, GDPR, state laws require that you then delete and destroy information that's no longer needed. So that's a principle. Individual rights, HIPAA access requests would be a great example of that. GDPR requires companies to respond to data requests from individuals, data subjects. So that would be a common one that you'll see across the board in various laws. The details are always a little bit different in each law, so it might be a right to restrict processing or a request to restrict processing in some cases. In other cases, you have the right to just have your information deleted. So there's different variations of those rights. Data security goes without saying, that's an important one. And then vendor management, so the idea of accountability throughout the chain. So once information is collected by your company, how is that then entrusted to you? Do you hire a vendor that handles that information as well? Or is it, the idea of having controls over that use of information downstream. So let's dive into some updates on state privacy laws, and I know everyone's really excited about this. I'll touch briefly on each of them. We won't go into super detail on all of them because there's a lot to cover, and we could probably spend a whole seminar on each law. We won't do that. We'll spend a slide. But to start off, let's get a question to the audience. Who here is dealing with a state privacy law, one or more of them, and attempting to comply? Maybe you're not involved in that directly, but is your company working to comply with these? Show of hands here. Any poll results there? We see this quite a bit.
Paul, on the poll, we've got about 78% are dealing with one or more state privacy.
So they are affecting many of our clients. Usually, you'll see as we go through some of the applicability thresholds, but they do affect a lot of clients that we have, and many businesses across the country. So we'll talk about the California Consumer Privacy Act briefly. And this isn't a very new law. It's been around a couple of years. But for many of you, you have some unfamiliarity with some of the requirements. It's been said it's similar to GDPR in a lot of respects, and that's true. One of the main kind of observable things that you'll see as you go through your normal life that's related to this is those banners on many websites that say, "Do not sell my personal information." That's a requirement from the CCPA. It's been in effect since 2020, and it affects businesses primarily that do business in California or have certain revenue thresholds that we'll touch on in a second in the next slide. It offers data subject rights. It requires data security, contract controls, various things that ensure privacy of data for individuals. It requires consent before you can sell data of individuals. So there's a lot of requirements. We'll just touch on some of them on the next slide, especially because it's been updated since 2 years ago with the CPRA, the California Privacy Rights Act. Now, what's kind of interesting, I think helpful for context, is that the CCPA originally was brought forward as a ballot initiative, so it was going to be voted on at the ballot box as this pretty broad privacy law. But rather than go that direction, the advocacy group that was bringing this ended up pressuring the legislature to pass that law instead through the legislative process. It didn't get much amendment in that process, and ultimately it was passed with some inconsistencies and some things that normally would come out of a law like that in a legislative process. That didn't happen until later, so some amendments happened, some clarifications needed to be made, and now we have the California Privacy Rights Act that passed last year and has a more specific focus on some of these areas that weren't addressed in that original law. Interestingly, this was passed through a ballot initiative. Most of the new provisions in this law are effective 2023. One of the big changes in terms of applicability is that originally it was if you have $25 million in revenue annually, this law applies to you, and you do business in California. If you buy, receive, sell, or share information of 50,000 individuals was the original threshold that the CCPA set, and it's been moved up to 100,000. So there's a narrower applicability that will be coming in 2023 than we've had so far. Or if the business derives 50% of its annual revenue from selling the personal information of individuals in California, then that would also trigger the law. Some of the really important, I think, changes that might affect you or your clients is the exclusion of employee data was extended. So the original law, they amended it to exclude employee information. And then the CPRA has extended that extension even further to the end of this year. We don't know for sure if that will continue to be extended or if we'll end up dealing with employee data under the CCPA as well. And then it also updated some of the sale and sharing information definitions. So rather than do not sell my personal information, those banners will say or share. Do not sell or share my personal information. Clinical trial data is excluded, and that was clarified further in the amendments. And then also any data processing that's kind of a significant risk needs to be reported and assessed and reported to this California Privacy Protection Agency. And this agency was also a new implementation from this law. So that's now the enforcement agency instead of the California Attorney General's office. Only a few more laws to go on the state side. Virginia passed their law, which is now effective January 2023 as well. And this applies to businesses, as you can see, that either process a fairly large volume of Virginia consumer data, so 100,000, or a much smaller number if they derive most of the revenue from selling that information. Again, provides data subject rights. You can see some of the consistency there with other privacy laws. And one thing to note too is this, again, continues the exclusions for PHI, for employee data, for business-to-business kind of commercial data that you'd collect during sales activity, things like that. And then it was amended slightly in the past few months to delete, basically this deletion right was replaced with an opt-out right within that law.
Hey,
So,
Paul, we
yeah.
do have a question that came in online. How long do we need to keep customer data for general promo and marketing in a CRM system? And is there anything we need to do with FDA in this area?
You know, I think as far as the FDA goes, they don't have any guidance that I'm aware of about deleting that data. So I don't see any reason why you would delete that information. We haven't really, as far as requirements for retaining it for a certain period, is that kind of what they're asking, I'm assuming? It would vary, I guess, depending on what specific regulation you're talking about. So we could certainly look at that. It's probably fact intensive, depending on what the database is for. Very similarly to the Virginia law, Colorado has its own privacy law as well. This applies to businesses that do business in Colorado and, again, collect information, process information about Colorado residents. Really, again, this is so consistent, I think, throughout these laws that they're really concerned with businesses that sell and do business with information as a commodity. So you'll see that that's a focus on all of these. Again, similar requirements in terms of data security, contract provisions, risk assessments. These things are pretty common in these. And then also doesn't apply to PHI, doesn't apply to employee data or to business data. One thing that I would clarify is these exclusions for PHI kind of vary a little bit by state. So for example, in Virginia, the exclusion is for the entity level. So if you're a covered entity, any information that you process is going to be subject to HIPAA rather than this law, whereas California and Colorado have focused on what is the classification of data that you process. Is it actually PHI or is it something else? And that's one of those distinctions. All right, moving right along, we have Utah. They have just passed their privacy law this year. It bears similarities to the prior laws that we've discussed here, but they've made a deliberate effort to narrow the scope. So you'll see that not only is there a threshold in terms of revenue, but also in addition to that, there needs to be a certain level of data processing that goes on of Utah residents. Provides the same kinds of rights, the same kinds of security controls, and really clearly they've made exemptions for PHI employee data, business-to-business data. And they've added another category that's excluded, and that's aggregated data, so any information that's been pulled into sort of a generalized pool of information that you can draw insights from. Just one more here. These are all very new, hot off the presses. So Connecticut just passed their law this past month, and it was signed about 9 days ago. And 14 months from now, it'll come into effect. Some of the requirements are familiar based on what we've just seen in the last couple of slides. They've made it a threshold of 100,000 Connecticut residents. If you process information on that number of Connecticut residents, it'll apply to you, except if all you do is handle payment transactions. So maybe you're a retailer that uses, handles credit card information or something. Or if you do get engaged in selling or commercializing data, then it's a much lower threshold. Similarly, provides rights, requires these assessments, security, all of those things that we're familiar with in most privacy laws. And then it, of course, again, and I think helpfully, this is showing a trend, does not apply to PHI, employee data, and business-to-business data. So here's just a quick comparison chart, which I think highlights some of the trends that we are seeing across these laws. Certainly this doesn't compare every aspect, and there are more things that we could look at, and there are differences. They each define personal information differently. They each define various terms, sale, and all of them in slightly different ways. But you can see that there's a trend here towards granting certain basic rights to consumers, to generally avoiding these private causes of action, which allows an individual consumer to sue on behalf, against the company if there's a violation. Typically, they've excluded PHI, although of course the details vary. For the most part, these laws have required some sort of risk assessment when there's processing that's of a high-risk nature. So that definition, of course, varies what is high risk, but there is some sort of threshold where risk assessments need to be done to evaluate the risk for the data subject.
Hey, Paul, quick online question, just
Yeah.
for a little bit further. Can you go a little bit more into what is considered high-risk processing under these laws?
Yeah, that's a great question. And so this kind of originated, this concept of high-risk processing, with GDPR, so the European General Data Protection Regulation. And for the most part, it's identifying the kind of processing that maybe is more sensitive information, maybe larger volumes of information, or maybe is used for things that might be more impactful to individuals. So if it's, for example, biometric processing, that you use someone's facial scan to maybe do predictions about what they might, like to be marketed with, or maybe you profile based on data about that person, what their credit history things like that would be more sensitive and affect their ability to exercise their rights. Typically, that would lead to, okay, this is high risk. It varies by law, but those are some of the examples we could see. All right, so we're out of the states and into the OUS update.
Real quick, Paul, though,
Yeah.
there is another question on the
Yeah.
states. So California requires specific language in informed consent documents for clinical trials due to their privacy laws. Does Colorado, Virginia, and other states with privacy law have those same requirements as California?
So typically, it would vary based on exactly what you plan to do with the data, what the data consists of, and we could look at that more in detail. But generally speaking, if there's a clinical trial, these laws have some sort of exemption for the data collected within that trial. So rather than have your data set then be subject to data subject requests and have potentially deletion requests, things like that, there's an intention, at least in most of these laws, to carve out clinical trials that are done based on good clinical practice, and there's kind of a variety of different carve-outs for that. So a question here, and I think a big topic in the OUS is international data transfer. How many here, by a show of hands, have dealt with this, maybe through a clinical trial that you're trying to get data from in another country or what have you? We have a few hands here.
Yeah, so we're getting close to like a 50-50 split online, 60-40.
Yeah, and that's consistent, I think, with what we see. Generally it's a challenge. It's a common issue. Even if you're a U.S. company that's trying to maintain mostly business in the U.S., you might be running a clinical trial in Germany or Spain or wherever, and within that context, you need data from the EU, and the EU is right now fairly difficult to get data out of. There are other countries as well with these kinds of restrictions. So with that in mind, if you're familiar at all with the GDPR, it includes restrictions on cross-border data transfers unless you meet certain criteria and address certain risks. And that's been the case for a long time. But over the past couple of years, this has gotten a lot more complex and difficult. The US Privacy Shield, which allowed kind of unhampered data transfers between the US and EU, was struck down in a court ruling that's kind of shorthanded to Schrems II by the European Court of Justice. And that led to a few other domino effects, one of them being that most US companies that do business or handle or interact with the EU are now using standard contractual clauses to transfer data between the countries and the country and the European Union. And that adds another set of complexities, including the standard contractual clauses were changed in the past year. So June 4th in 2021, there was a brand new set of standard contractual clauses that were issued. And there's kind of this sunset period for the legacy contracts, and now everyone is scrambling to replace their old SECs with the new ones, and that's been going on for the last year and a half or so. But what's sort of driving that now is that by the 27th of December, everyone who has legacy contracts will need to completely move them over to the new versions by the end of the year. And if that weren't enough, there's also this concept from Schrems II that has led to these data transfer impact assessments. So any time there's a transfer of data from the EU to the US, there's this questionnaire. You've probably seen it if you're involved in this at all, or a variation of it that looks into not only what is the transfer made up of, what kind of security controls are in place, but what about the sort of government surveillance in the US, what kind of access might they have to this data, and analyzing that. And that's become a big topic of kind of contention and challenge in the privacy world here. The good news is, though, there is a US-EU data transfer agreement in principle that's been agreed upon between the government of the EU and the US as of March 25th. Of course, Max Schrems let everyone know that he plans to challenge that as soon as it's published and confirmed. So we'll stay tuned. Quick note on the GDPR in the UK. So since Brexit, there's obviously the EU no longer has laws that apply to the UK. However, the UK has implemented its own versions of these laws, including most recently some new standard data transfer agreements. So you can see this trend is continuing. There's these new addendums and agreements came into effect the 21st of March. They are a little bit simpler than the EU standard contractual clauses, and they're designed to be able to addend onto the EU SECs so that there's not quite as much effort involved in implementing those. And the ICO, the Information Commissioner's Office in the UK, has offered a lot of guidance and provided some good templates for that too. But again, it's a lot of additional labor. Canada has not wanted to be left behind, so there's been some additional activity there, and there's more than this, but just to highlight one of the areas of change, Bill 64 begins to take effect in September this year, with some of the key provisions taking effect next September. But similar to GDPR, one of the most kind of surprising things is The penalties can be extremely high with this new law. Typically around 4% is the maximum, and then in this case, with repeat offenders, the law would allow up to 8% of global turnover to be issued as a penalty, or $50 million, whichever is the greater of the two. And then it also brings in some unique cybersecurity incident requirements. So if there's a data breach, as we kind of commonly think of it, there's no longer in this law an idea of sort of evaluating the risk before considering it an event that needs to be registered and logged. They will consider a confidentiality incident to be the point where you start to document and treat it as a potential breach. And of course, they also have cross-border data transfer obligations that are being implemented with these impact assessments as well. China, I'll just briefly mention this one, but they've had this law in place since November last year and in effect. And some of the requirements are familiar, similar kind of penalty levels to GDPR. And coming soon, there will be some standard contractual clauses for China as well. So that kind of wraps up the OUS update. Cybersecurity is just, and this is not the FDA cybersecurity discussion. Bryn will handle that. This is data security within the US and abroad, and some of the recent developments on that front. Every federal agency seems to be interested in some respect in regulating or getting involved in cybersecurity. The SEC recently issued a proposed rulemaking on the topic, looking at trying to ensure that boards and really publicly traded companies, of course, are properly reporting and having transparency around their cybersecurity situations, and including the right kind of disclosures at the board level. So that's kind of in process right now with this proposed rulemaking. The FTC has for a long time been kind of a primary regulator for cybersecurity and privacy in the US. That's not changed. They still are in the midst of this, and what sort of the FTC has done is take a bit of a watchdog role in prosecuting companies that under the unfair and deceptive trade practices standard. So if any sort of data security fails in a sense, it's not reasonable, or some other issues, data breaches, the FTC is interested in identifying those and determining, is this an unfair trade practice because it was the security wasn't reasonable, or was it a deceptive trade practice because the privacy policy said this and they actually did that, or the consent form said this and they actually did that. So that's the basis for a lot of the FTC actions here. One thing to note too that I think is especially relevant for this audience, the FTC has this health breach notification rule, and the focus of that is really these kind of in between applications, mobile applications and so on, that don't have covered entity status, so they're not subject to HIPAA. So no one's necessarily regulating the privacy of that information directly, at least at the federal level. So the FTC has stepped in and made some rules around that, and that's what this is about. All right, one more on this front. The False Claims Act has recently been brought into effect, kind of brought to bear against cybersecurity failures by government contractors. Kind of an interesting case, but there was a first case in this initiative that focused on a company that was providing EHR, an electronic health record, to the department, the State Department, and in the process they assured them contractually this is a secure platform, all the data that we gather is going to be secure, but allegedly not all of the data was secured, and so they were prosecuted based on a claim that they made, a submission to the State Department that was allegedly false, and so that is based on the False Claims Act, which we all know goes back to kind of Civil War times and has been used in the healthcare industry and so on to prosecute fraud. So question for all of the audience, who here is seeing requests about cybersecurity, whether it's from boards, from diligence, or from customers? Who's seen a lot of it?
Give the poll a few moments online.
Yeah, it's okay. Yes, typically I feel like cybersecurity is almost in some ways just, it's still growing, even though it seems like we've hit critical mass and everyone knows this is a big deal. We keep seeing more and more rigor around the questions that get asked on this.
Yeah, 80% online say yes.
Okay. Yeah, that doesn't surprise me. I'd be shocked if not everyone at some point, every business starts to see something about this that they need to answer to. So let's wrap up with an enforcement update. I'll touch on just a few things. OUS, unlike our favorite Sesame Street character, the French DPA doesn't care for cookies. So we've seen a lot of enforcement on cookie consent types of issues in the EU, and most recently, this cookie legislation in France led to about 210 million euros in fines levied just within the 9 months that this law was in effect last year. The Austrian and French DPAs both determined that two website operators, kind of separately, but two different website operators' use of Google Analytics was not compliant because, in their view, Google Analytics collects personal data and then it transfers it to Google's kind of servers in the US, and that is considered a data transfer. So we're right back where we started. This is a data transfer issue, and that's part of the concern here. Yet to see what kind of fines might be issued under that, or if we'll continue to see other regulators hop on board. But I understand Google is trying to fix this issue or find a way to offer their product that won't cause these problems. The CCPA, some enforcement action there. About 2/3 of the enforcement there so far has been on privacy policies, or kind of these public-facing things that the company website might include. So pretty low-hanging fruit, and that's been the focus so far. You can go to the California AG's website and look at some of the examples. HIPAA, not a lot of enforcement on sort of data breaches or these bigger entities, but we've seen this right of access initiative, which is targeting individuals who request access to their PHI, targeting sort of providers that haven't been responsive to those requests and enforcing against that. So we've seen 1.6 million in settlements and fines, penalties, and sometimes these are such small incidents that it's maybe one individual patient who complains that I didn't get access to my information, and that leads to one of these settlements. So key takeaways, privacy is continuing to grow. We see a lot of enforcement and regulation ramping up right now. Privacy programs can help reduce those risks, though. As the law changes, the program can adapt and cover some of these common threads that we see in privacy law. Good news in the US, we have a lot of state privacy law momentum around excluding PHI, so covered entities and BAAs can have a little bit of reprieve from that. And then public-facing activities tend to lead to enforcement. So a lot of the enforcement we see tends to be cookie consent or your privacy policy or responding to data subject requests, these things that are very visible. So those are ways to reduce risk, is to look at what is our more public footprint. No comprehensive federal privacy law yet. We kind of hoped or thought maybe next year. And so far, it doesn't look like there's anything likely to come through. I do think we can see some trends that might inform that future privacy law when it does happen, but it might be a few years down the road yet. And of course, cybersecurity, big emphasis. We see constant activity on that front, both regulatory and in terms of data breaches, ransomware. All of these things continue to be a significant topic. So that about wraps it up. Any questions? Perfect. Brandon, I guess I'll hand it over to you for the FDA cybersecurity update. Oh, we have a question.
Thank you. That was great. when it comes to the California law and the other ones, kind of two questions. One is sometimes health information is run in like an AI machine learning model, and so that becomes the product. And so in these laws, I'm assuming that you'd have to somehow retroactively remove that patient's data, rerun the model. That may potentially affect the end product, depending on how many patients request their data to be removed. Is that what these laws are requiring?
So generally speaking, what sort of is interesting is the law applies to the processing of personal data. So during the phase where you are processing certain data, that's subject to the law. If you get to a point where the data is no longer relevant to what you're doing with that, you probably can move forward and use the product. But we have seen instances where, and I didn't put it in this deck, but there's a recent enforcement case where a company was forced to lose some of their product that they developed through an unlawful, I think they used children's consent in that case, but there was an unlawful use of data that led to kind of an output, and that output was then required to be destroyed as well. So there can be some implications there, but it's the use of the personal information that's regulated by the law.
Okay. Yeah. And then the laws, do those, let's see, what's the best way to put it? Like if the customer gives consent to use their data in any way we or the company needs, do these laws overcome that, or is that signed consent agreement the one that's more binding?
Yeah, so I think the key thing is most of these laws, and all of them, to the extent a patient consent is obtained, are going to allow you to do things as long as that consent was obtained properly and has the right kind of elements to meet the standards of the law. For example, a big topic in the EU right now is if I get consent, but I've sort of designed my cookie consent in a way that makes it so easy to say yes that no becomes a really awkward and difficult thing to provide, is that really consent? And that's the kind of question that many of these laws are starting to address. So as long as that consent is collected appropriately, generally that will help. Yep. All right. Do you have one of you?
And I apologize, I did not have instructions on this ahead of time. So just a little bit of my bio. I started my career in design assurance at Boston Scientific. And then from there, I worked in various engineering roles and kind of touched all aspects of quality going forward. I started at Gardner Law about 2 years ago. And that's been really great, kind of working from the other side of things. Kind of once I was on the inside, now I'm on the outside a little bit. So I kind of have both viewpoints covered there. So, okay, that's the wrong one. Which button? It's giving me a laser pointer. The big giant green button. Got it. So this was actually probably a well-designed device that I maybe, it's a little bit of a user error here, but yes. Okay, so the agenda, and I will try to go quickly through these slides because I know we're a little bit behind on time still. So there's going to be just a quick background on cybersecurity. There was a new draft guidance that came out that I have highlighted there in the next piece. So I have this other in the news segment, which I said, but it's really only one slide. It's very brief. There's a lot you could cover with cybersecurity. This is just skimming the surface. Changes then from the 2018 draft guidance and kind of highlights of that 2022 draft guidance that have just come out from the FDA regarding cybersecurity. And so this is sort of a quote that the FDA had as far as their why they decided that they needed to release another draft guidance beyond what they had in that 2018 draft guidance regarding cybersecurity, which is just that we're seeing more threats, we're seeing bigger threats. It's becoming critical that we address cybersecurity, and like Paul mentioned, it's kind of a big topic around this industry and others as well. So there's been a lot of incidents over the years, and they're getting worse. So this is something that really needs to get driven home as far as something that we need to try to protect ourselves against. So cybersecurity incidents, and this is sort of kind of stating the obvious, but they can render medical devices and hospital networks inoperable. They might disrupt the delivery of patient care. There was an example that I don't have covered in this slide deck recently where a hospital basically was shut down because of a cybersecurity incident. And in that case, there was a lot of patients that weren't able to get the care that they were scheduled for because of that threat. And that kind of goes with that third bullet where it can delay diagnosis, treatment, and it may also lead to patient harm. So there's kind of a couple things, and we'll talk about this a little bit later, but it's not just a patient harm thing, it's also just a data security thing in general. So cybersecurity kind of has two kind of main reasons that we're sort of driving home to get that implemented, at least in the medical device space. So this is the very brief kind of in the news segment. Starting kind of back in 2012, I think I have the date on there, I maybe covered it up, but yeah, August of 2012. That's sort of when the FDA kind of started this process of kind of considering cybersecurity more formally, releasing draft guidances, sort of doing that consideration on what they need to kind of focus on as far as for medical devices and ensuring that those things are secure. There's kind of a famous piece in the news, and there was also apparently, I don't watch the show, but this is everything that I've heard about this incident, where there was also an incident on the show Homeland where they were hacking into medical devices. And then there was the whole Dick Cheney, perhaps his defibrillator was going to get hacked, so that was actually modified. These were all, it kind of came straight from the movies and then became part of real life. And then I just have sort of an example there that's a little bit more recent of the FDA actually sharing a safety communication regarding cybersecurity. There's many, many more headlines I could have included in here. The FDA has issued additional safety communications, not additional ones, but the FDA continues to monitor this and relay safety communications and focuses on cybersecurity as we're going forward. So the draft guidance from 2022, which just sort of very high level here, this one focuses more on the total product life cycle. And there's not really any surprises here, I guess I would say, as far as what they've released in this new guidance. It's kind of continuing along the same path the FDA has gone on with other things such as risk management, product development, where they're focusing very much on the total product life cycle, continuing to monitor things, baking things into your product development cycle. That's sort of, the same sort of key things that they're pointing out in this 2022 draft guidance that came out. And then there are additional recommendations for pre-market submission content, but I just want to emphasize that it's not limited to the pre-market submission content. It's sort of, you kind of need to have that stuff as you're doing your product development, so that, like Amanda was mentioning in hers, that you're not getting to the point where you're saying, I'm ready to submit, and it says, and everybody says, well, where's your design controls? This kind of thing needs to get baked in, and that's where the 2022 draft guidance is a little bit more, it emphasizes that point a little bit more. So the major changes from the 2018 draft guidance, the change in title, and this is just, the FDA stated to better capture the scope. Really, though, this is more emphasizing that point that it's not just your pre-market submission. It is additionally stuff that's done on the front end as part of your product development, and stuff also that's done on the back end as part of post-market surveillance. So it needs to get put into your quality system and not necessarily just in your submission. So that's where that change in title comes in. Document structure change. This is, again, there's kind of the same way to say the same thing. They introduced a secure product framework, which is sort of just a different way to kind of consider cybersecurity as part of your product development process. Risk tiers have been removed. However, they did not eliminate the concept of risk from the guidance. They've removed the specific tiers, but they do still say if you're going to be putting in cybersecurity controls, we want you to put them in considering the risk of your device. So that's not, they're just, those specific tiers have been removed, but not the concept. The Cybersecurity Bill of Materials has been replaced with a software bill of materials. So we'll go into that in a little bit more detail. Kind of the main takeaway there is just, it's a little bit easier for industry to meet this standard. But I have another slide that will kind of talk a little bit more about that. And then additional changes from the 2018 guidance. So this is, again, additional clarification regarding the submission document. So it's sort of in this in the 2022 guidance sprinkled throughout on what you should include as far as stuff in your submission, but that kind of falls along the same lines as everything else that I've kind of been repeating here, where it needs to be baked in. So if you kind of implement this kind of correctly, I guess I'll say, in your system, this should automatically happen for you, but that's just another way that the FDA is kind of emphasizing that point. Investigational device exemptions have been added into the scope. So again, going along with design controls in the product development process, those were always required for IDEs. The FDA is just explicitly saying that you also need to consider cybersecurity as part of that. And then again, the total product lifecycle approach. So, you know, once you've done the submission, once your product's on the market, you don't just get to forget about cybersecurity. You need to continually monitor it, and you need to make changes based on kind of the data that you're seeing there. And then also it aligns with a May 2021 executive order on improving the nation's cybersecurity. And we'll touch on that a little bit more. That's mostly just the aligning of the language for the cybersecurity bill of materials versus the software bill of materials. Okay, so the secure product development framework. So this is, as part of the 2022 guidance, this is sort of the high level, top level way that they want you to show that you're meeting those QSR requirements for the quality system regulation. And again, this is a set of processes to kind of help you get there. So this includes more than just product, I mean, it includes product development, but kind of all aspects that might touch product development. So kind of your requirements management, risk management, even usability, that kind of thing. So those are all part of this secure product development framework thought process. It's just got an added layer of now you also need to consider cybersecurity as part of this. So risk management, I will try not to go into this in too much detail. There is a kind of focus more in this 2022 guidance versus the 2018 draft guidance that came out on what they call threat modeling for risk management. They do emphasize in this new guidance that you are, you're still following some of the concepts that are in 14971 if you're familiar with the risk management standard, but the cybersecurity risk management is specific to what they say is looking for, where was my note here? I guess I didn't write it down, but so the 14971 is looking more at kind of patient safety. There are potential cybersecurity concerns that might be even in conflict with the patient safety. So it's not like you can just take your 14971 risk management process and just say that you're done, you have that done, cybersecurity's completed. There's a whole sort of other risk management process specifically geared towards cybersecurity concerns, which can include things like business risk, which you normally wouldn't include in a normal, I call it a normal, I guess, 14971 risk management process. So that doesn't mean that you can't use both together, but they do have some things where there's going to be some differences that the FDA is going to expect that you've covered as part of your submission and also as part of your product development process. The FDA had provided some funding to come out with this playbook for threat modeling. That came out in November 2021. Now that's like 100 page, I think it's 91 pages. specifically geared towards just threat modeling and things that you can do to make sure that all of your cybersecurity risks are considered and that they're controlled appropriately. So there's a lot more detail than what you would normally include as just part of your risk management process per 14971. So it'll be important kind of going forward to make sure that kind of the concepts in that playbook are incorporated into the products or the company's quality system as well as into their products DHFs. So cybersecurity bill of materials versus the software bill of materials. What's kind of been said about this is it's not letting kind of perfect be the enemy of good here. A cybersecurity bill of materials is certainly more thorough. It includes software and hardware. But the software bill of materials is in alignment with that executive order, and it's a little bit easier for manufacturers to meet. So we'd rather have everybody at least get that far than think that this is such a huge burden that they're not meeting it at all. So that's kind of where that big change in this draft guidance came into play. Oh, I guess I should point out, I have it on the bullet, but most vulnerabilities will be software related anyway, so you are catching most of the things as part of that software bill of materials that you would likely need to see. So. And then, so cybersecurity for pre-market submission. So the FDA has, like I've mentioned, they have mentioned throughout the 2022 draft guidance that this is not just a pre-market submission, check the box type activity. It's what they've said is it needs to be built in and not bolted on. So this needs to be considered kind of at product conception. These 5 things that I have here in the bullet, those you may even consider kind of including way up front in your product development process as sort of you're collecting voices before you even develop requirements for your product. So that's where the FDA is going to look specifically that those are met. If you have them kind of initially conceived as part of your product development process, it will be a lot easier once you get to your pre-market submission to make sure that you're able to say, yes, we have considered these, and this is where they are. So those specific 5 items will be reviewed by the FDA as part of the product submission. And then kind of the last slide here is just the other pre-market submissions, that stuff that the FDA is going to look for. So I mentioned earlier that those risk tiers were removed, but the FDA is still expecting that you are going to provide information that is with the appropriate level based on the risk of the device. So if you have a really low risk device, not for patient safety necessarily, but a low risk cybersecurity device, that's where you won't have maybe as much cybersecurity information in your design history file. But if you have a really complicated device that has lots of vulnerabilities, that's where you're going to have to make sure that you submit all that to the FDA so that they can do a full review of kind of the entire cybersecurity risk. And then basically just driving the last point home, that they're going to look at your cybersecurity as part of your substantial equivalence. So if you have a device that's similar to another one, that's going to be a big part of the submission too, is just to make that comparison to show that your cybersecurity risk is now not just necessarily a safe and effective kind of comparison that you would normally be doing. So that is all I had. There's probably a lot more we could talk about. Yeah, go ahead.
Is it fair to say that risk from cybersecurity will not always mirror risk of classification of the device? So like a class 3 may be high, but also a class 1 could be high depending on what it does?
Potentially. So the FDA they touch on that. They don't directly talk about that in the draft guidance, but they do touch on that a little bit, saying that kind of how you're supposed to assess that cybersecurity risk level. So it's not necessarily based on patient risk. Like I said, it's going to be if you have like literally a brick that can't touch anything, at all, that's going to be a low risk for cybersecurity type aspect. But that doesn't necessarily mean it's a low risk device, because there's a different set of criteria that they're looking at.
Yeah, thanks.
I haven't had a chance to look into this yet because I don't have a client with a pre-sub for the moment, or not a pre-sub, sub. In the new guidance, are they consistent in saying then if you're making updates to your software as a medical device and you're just updating it to increase cybersecurity, you wouldn't have to resubmit
They don't touch on that specifically.
in this guidance?
No. Yeah, you would have to kind of go through the normal kind
Yeah.
of change.
Because if the
Process.
change is only changes to software, if the change is only to increase cybersecurity, you don't have to submit again.
You may have to.
Okay.
Yeah, and they don't kind of go into that level of detail in the guidance, but it depends, I guess, on what the change would be. There's potential that you may have to resubmit because it is considered as part of that substantial equivalence. So.
Yeah, that's my question. I should have maybe specified that a little bit better because it's not going to necessarily be, it's going to be a judgment call.
Yeah. Yep.
Okay.